So, John, we get a lot of calls from people who are in the investigation phase of their issues. And I'm telling you, we've had a recent uptick in people who have been accused of fraternization and inappropriate relationships. So in the Army, particularly, it's Army Regulation AR 600-20, paragraph 4-14, that prohibits an inappropriate relationship. And the thing that's really kind of squishy about this is it says relationships between soldiers of different ranks are prohibited if it causes some type of issues with command or there's a perception of favoritism. Have you had any of those cases recently?
Yeah, what you mentioned, Will, there has been an uptick of these types of allegations within various commands, especially here in Europe. We've found that a lot of commands, a lot of units have been deploying into all kinds of areas where there may be close living quarters, restricted space to roam around, and their liberty is somewhat restricted due to the mission set. So what that causes is a lot of more familiar types of relationships to develop among soldiers, which may not necessarily be in violation of the policy or the regulation, but tends to kind of be looked at a bit more closely. And you're right, the perceptions and appearances are the blurry lines in this policy.
You know, what I've noticed is your typical case is, there's a group of people who are friends, different ranks. They go to the gym, they eat chow together, they go to the movies together, and then someone gets mad at someone. And when someone gets mad, then it's a matter of, well, Sergeant Smith and Lieutenant Jones are too friendly, and I think he's getting favorable treatment because of that relationship.
That's a typical fact pattern that I've seen over and over. And hey, it's human nature. People love to talk. People love to gossip. They love a juicy story of a possible relationship between an NCO and a lieutenant. What else is there to talk about and do other than to gossip and spread rumors about such a thing? And when this gossip and rumors reaches the level of command, they have to look into it.
Right, and when they charge an investigating officer to look into this, they're briefed about the perception piece. And when they're briefed about perception, that puts a whole new focus on that relationship. Because it could be a perfectly legitimate relationship, and you've got one, maybe two soldiers who are like, oh, I think you're getting favoritism. And then that categorizes that relationship as prohibited and equals fraternization.
Right out of the gate. I mean, all of these investigations start with the rumors. They start with the perceptions. That's the framework right out of the gate on these investigations. And the IO is human too. It's an untrained investigator that's going to come in and look at these perceptions, these rumors, this gossip. And a lot of times they have already built a framework within their heads of what the outcome or what this whole situation looks like.
Right, and our soldiers are facing, charges under Article 134, the Uniform Code of Military Justice for fraternization, or an Article 92 violation for violating a lawful order. It really is difficult. Now, if a soldier wants to read what the Army policy is, Department of the Army pamphlet 600-35 gives a whole list of examples of what would be a prohibited relationship based on perception. And when I read through that, I was stunned at some of the things that the Army says is prohibited.
Right, because I read the same examples, and a lot of these examples are just everyday normal interactions among soldiers, but when looked at a particular way or seen a particular way, and it gets into the wrong set of eyes, then here we go with an investigation.
So what does a soldier do when they're facing an allegation of fraternization?
One of the first things they should do is not speak to anybody, including the IO, their command, their colleagues, their peers, or subordinates about anything until they've spoke with a lawyer.
Absolutely. Getting a lawyer is critical because the lawyers are able to sit down, look at the allegation, talk to the person who's the subject of the investigation, and make a determination, hey, do we cooperate with the IO? Under what conditions do we cooperate? Is this really a frat issue, or is this something that can be recontextualized as to being innocent behavior? And you cannot do anything until you talk to counsel.
That's correct. And the counsel is going to identify witnesses, identify the sources of the rumors, essentially conduct their own counter investigation to determine more of what the truth is in this situation. Because remember, the IO is also operating on a timeline. The IO is untrained in investigations, and it's a second or third additional duty that they have among many other duties. So they're on a timeline. They want to finish this investigation as quickly as possible. We have the time and the personal connection with the client, and we're able to go in and do a more thorough investigation.
What should not happen is the person who's subject to the investigation shouldn't try to go out and do their own investigation.
Absolutely not. Many times in investigations like this, you will see an accompanying military protective order or a no contact order. Under no situation should a client ever try and talk to their peers, talk to anybody involved, particularly with the other party who is alleged to be involved in the relationship itself. Because then you run a risk of violating another order, a military protective order, or an obstruction of justice charge.
I tell you, I've seen multiple obstruction charges come back founded because the subject did their own investigation when the underlying investigation was unfounded. And you're still in a hot water at that point in time.
And it would be sad if that was the remaining allegation, just an obstruction of justice charge, because the client was too eager to go out and start their own investigation.
Right. I think it's essential for the person who's the subject of the investigation to maintain their professionalism, right? Should be like water off a duck's back. They should go out and perform at high levels and continue to do what they do so well.
Right, and let your counsel then establish good rapport and relationships with your chain of command. Let them establish good relationships with the witnesses, the investigating officer involved. Let your counsel do the work for you.
Right, and that's where we as counsel would address misrepresentations made by witnesses, fundamental flaws in the investigation, or things that had not been done. That would be our process. Now, in the unfortunate event that there's a substantiated finding, then there are many appellate processes, whether you respond to an AAIP, or you take it to a higher level of command, or if there's some adverse action taken in your official file, going to the suitability board, or even the Board of Correction and Military Records. But those are all things that you need to get counsel involved in early to set up your defense.
That's right, because getting counsel early on in the investigation can help steer off many of these different branches of potential adverse actions that could be waiting for you.
Right. If you're facing charges of fraternization, give us a call today. My name is Will Helixon. We are the law office of Will M. Helixon. You defend the nation. We defend you.